The Armed Forces Special Powers Act, AFSPA, is a hotly debated piece of legislation in India and beyond. In this lecture, we shall examine this act in the light of human rights standards in India and the responses from various democratic institutions like the Parliament, the Supreme Court, the National Human Rights Commission, and various other official commissions and committees set up for this purpose. In India, the Protection of Human Rights Act 1993 defines human rights as the right relating to life, liberty, equality and dignity of individuals guaranteed by the Constitution or embodied in the international covenants and enforced by the courts in India. The Constitution of India in Part 3 enshrines several fundamental rights of its citizens. Some of the relevant fundamental rights may be summed up as below. Article 21 expressly declared that no person shall be deprived of his life or personal liberty except in accordance with procedure established by law. Article 14 ensures to all its citizens equality before law and equal protection by law within the territory of India, which means that no citizen or group of citizens shall be discriminated vis-a-vis any other citizen or group of citizens. Article 19 confers upon the citizen 6 valuable freedoms: freedom of speech and expression, freedom to assemble peacefully and without arms, freedom to form associations or unions, freedom to move freely throughout the territory of India, freedom to reside and settle in any part of the territory of India, and the freedom to practice any professions and to carry out occupation, trade and business. Article 22 in clauses 1 and 2 confers equally valuable rights upon the citizen of India. Clause 1 declares that no person who is arrested shall be detained in custody without being informed as soon as possible of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Clause 2 declares that every person who is arrested, detained in custody shall be produced before the nearest magistrate within a period of 24 hours, excluding the time taken for the journey from the place of arrest to the nearest court of the magistrate. The Constitution bestowed upon the Union and the state to not only respect these rights, but also to put them under an obligation to ensure the conditions wherein the citizens can enjoy and avail of these rights. The provisions of Armed Forces Special Powers Act states that once an area is declared as disturbed under Section 3 of the Act, special powers is available to commissioned or non-commissioned officers of the armed forces. This special powers available under Section 4 are: number 1, the power to use force, including opening fire, even to the extent of causing death, if prohibitory orders banning assembly of 5 or more persons or carrying arms and weapons, etc. are in force in a disturbed area. Number 2, the power to destroy structures used as hideouts, training camps, or as a place from which attacks are likely to be launched, etc. Number 3, power to arrest without warrant, to use force for the purpose. And 4th, the power to enter and search premises without warrant, again, to make arrest or recovery of hostages, arms, ammunitions and stolen properties. Section 5 of the same Act requires that persons arrested by the armed forces be handed over to the nearest police station with the least possible delay, along with a report of the circumstances occasioning the arrest. And Section 6 gives the member of the armed forces discharging these duties under the Act immunity from prosecution and other legal proceedings except with the prior sanction of the Union government. The wording of the provisions of Armed Forces Special Powers Act on the face of it appears to infringe upon the fundamental rights guaranteed by the Constitution. How can one use force to cause death be authorized when 5 people are gathered? Can a person be killed for carrying a stick because that can be used as a weapon? How can search and arrest be conducted without warrant? And how can legal impunity be granted to erring soldiers when heinous crimes like rape and murders are committed? Well, to answer some of these questions and to understand how such a law came about in the first place and how it perpetuates itself despite the constitutional guarantees of right, we shall start with exploring the historical context. Historically, a law conferring vaguely defined powers to the armed forces appeared in the Statute Books of India in 1942. It was a critical period in the colonial rule. On the one hand, in Bombay, the All India Congress Committee decided to launch the Quit India movement. And on the other hand, in Singapore, some 40,000 British Indian soldiers joined the Indian National Army and were marching from the Eastern Front together with the Japanese soldiers. In a sweeping move, the Congress was declared as an illegal organization and prominent leaders were arrested and jailed. A mass upheaval broke out all over India. It is at this critical juncture that Viceroy Lord Linlithgow declared emergency all over the British India and promulgated the Armed Forces Special Powers Ordinance on 15th of August 1942. Interestingly, exactly 5 years later, on the same day, the British left and India gained independence. Immediately after the independence, the country faced a huge problem of partition and resistance from princely states to integrate. To deal with this situation arising from in certain provinces, the Governor General issued ordinances. These provincial ordinances were subsequently replaced by the Armed Forces Special Powers Act of 1948. This act, of course, was a temporary statute and finally repealed in 1957. Again, in May 1958, in response to the situation arising out of the insurgency of the Naga National Council demanding their self-determination, the President of India promulgated Armed Forces within bracket Assam and Manipur Special Powers Ordinance 1958. When this bill was introduced to replace the 1958 ordinance during the monsoon session of the Parliament, many members of the Parliament opposed it. They pointed out that the blanket power conferred to the army by this act would lead to violation of the fundamental rights of the people. And this act would circumvent the Constitution by effectively imposing an emergency in these areas without actually declaring one, and that it would abrogate the power of the civil authority in favor of the armed forces. Mr. Mohanty, MP from Dhenkanal, even raised a point of order on the ground that the bill cannot be discussed without invoking the emergency provisions in Article 18 of the Constitution, as the bill suspends the fundamental rights of the citizens in disturbed areas. Sri Laisam Achow Singh, MP from Inner Manipur constituency, also said, quote, "This piece of legislation is an anti-democratic measure and also a reactionary one. Instead of helping to keep the law and order position in these areas, it would cause more repression, more misunderstanding and more unnecessary prosecution in the tribal area. This is a black law. This is also an act of provocation on the part of the government. How can we imagine that military officers will be allowed to shoot and kill without warrant, arrest and search? This is a lawless law. There are various provisions under the Indian Penal Code and in the Criminal Procedure Code. They can easily deal with the law and order situation in this part. I am afraid that this measure will only sever the right of those people and harass innocent folks and deteriorate the situation. However, the few voices of dissent were drowned out, and after a brief discussion, the bill was passed in both the houses of the parliament and finally received the president's assent on 11 September 1958. Subsequently, amendments to this act were also made, which gradually expand the territorial scope of its application. Today, the act applies in the northeastern territories of India, comprising the 7 states, namely Assam, Manipur, Tripura, Meghalaya, Arunachal Pradesh, Mizoram and Nagaland. In 1990, a similar act was enacted to cover the state of Jammu and Kashmir. In the post-emergency era, the Indian judiciary struggled hard for a facelift with judicial activism. Novel procedures like the public interest litigation revolutionized the Indian judiciary. Riding on this euphoric wave of judicial activism, a few Manipuri students studying in Delhi under the banner of Human Rights Forum Manipur filed a public interest litigation in the Supreme Court, challenging constitutional validity of Armed Forces Special Powers Act. Subsequently, the Naga People's Movement for Human Rights and others also moved writ petition to the same effect, and some appeals from the High Court were also added to it. But it was only on 27th of November 1997, after 17 long years, that a 5-member constitution bench headed by Justice J.S. Burma pronounced the final verdict, and the constitutionality of Armed Forces Special Powers Act was upheld. The court ruled that the power conferred under Section 4 and 5 of AFSPA on the officers of the armed forces are not arbitrary and unreasonable and are not violative of the provisions of Article 14, 19 and 21 of the Constitution. They rely on the premise put forward by the Union of India that, quote, an inquiry is made whenever complaints about misuse of power conferred under the Central Act is received, and that on inquiry most of the complaints were found to be false, and whenever it is found there is substance in the complaint, suitable action has been taken up against the persons concerned under the provision of the Army Act. Well, the ground reality is very different from the government's claim. There are scores of cases where suitable actions has not taken even after official inquiries clearly establish human rights violation by the armed forces. There are still many more cases where proper inquiry have never been conducted. In the course of the hearing, the Supreme Court did not entertain any documentary evidence of individual cases for illustration of the true picture. In fact, 16 years down the line, after the judgment was pronounced, and following a public interest litigation moved by the Extrajudicial Execution Victim Families Association Manipur, a high-power fact-finding commission headed by Justice Santosh Hegde have unearthed this pattern very clearly. The judgment did rule that the do's and don'ts issued by the army authorities should be strictly followed, as they are binding, and disregard of the said instruction would entail suitable action under the Army Act 1950. But in practice, the do's and don'ts are often violated with the knowledge of and violations covered by the higher army authorities. A classic illustration of this practice is the Thangzim Manorama's case. In July 2004, the 32-year-old Madan was picked up by the armed forces from her house in the middle of the night. Next morning, her body with telltale signs of torture and rape was found in the paddy field. This conduct obviously violates the entire list of do's and don'ts, but no action was forthcoming from the army authorities. On the contrary, they spared no effort to shield off the perpetrator from any kind of legal scrutiny. For example, when the Manipur government instituted a fact-finding commission, the army authorities moved the court to stop it. Having failed to do so, the army authorities again moved the court right up to the Supreme Court and successfully suppressed the report till date. The Supreme Court, while upholding the Armed Forces Special Powers Act, did caution that, quote, the primary task of the armed forces of the Union is to defend the country in the event of war and when faced with external aggression. Their training and orientation is to defeat the hostile force. A situation of internal disturbance involving the local population requires a different approach. Involvement of the armed forces in handling such situation bring them in confrontation with the countrymen. Prolonged or too frequent deployment of the armed forces for handling such situation is likely to generate a feeling of alienation among the people against the armed forces. The National Human Rights Commission, NHRC, intervened in the Supreme Court case on behalf of the petitioners. But once the judgment is passed, the NHRC also seemed to have shied away from the issue. Of late, of course, the NHRC have expressed its discomfort over the Armed Forces Special Powers Act while reporting to the Second Universal Periodic Review of the United Nations. In certain parts of the country, the law has been enforced continuously for more than 55 years now. As envisaged by the Supreme Court, one such occasion wherein the anger against the armed forces did burst out in fury was in Manipur in 2004, following the rape and murder of Thangzim Manorama. The world was shocked to see the photographs of elderly women protesting naked with a banner saying, "Indian Army, rape us." And for the next 2 months, Manipur was simply ungovernable. It was only after the Prime Minister personally visited and assured that Armed Forces Special Powers Act will be replaced by a more humane act, the situation calmed down. In November 2004, the Union Ministry constituted the committee to review the Armed Forces Special Powers Act. Under the chairmanship of Justice B.P. Jiban Reddy, former judge of the Supreme Court, Dr. S.B. Nakande, former Vice Chancellor and jurist, Sri P. Srivastava, IAS, retired, former Special Secretary, Ministry of Home Affairs, Lieutenant General V.R. Raghavan, former Director General of Military Operations, and Sri Sanjay Hazarika, journalist, as members. The terms of reference of the committee are: keeping in view the legitimate concern of the people of the Northeast region, the need to foster human rights, keeping in perspective the imperative of security and maintenance of public order, to review the provisions of the Armed Forces Special Powers Act 1958 as amended in 1972, and to advise the Government of India whether A. to amend the provisions of the Act to bring them in consonance with the obligation of the government towards protection of human rights, or B. to replace the Act with a more humane Act. The committee, after conducting widespread consultation, submitted its report on 5th June 2005 and concluded that Armed Forces Special Powers Act is too sketchy, too bald and quite inadequate in several particulars. It should be repealed. It clarified that, quote, "It is true that the Honorable Supreme Court has upheld the constitutional validity, but the circumstances is not an endorsement of the desirability and advisability of the Act. When the constitutional validity of an Act is challenged in the court examines 1. Whether the Act is within the legislative competence of the legislature which enacted it, and 2. Whether the enactment violates any of the provisions of the Constitution. The court does not, it is not supposed to pronounce upon the wisdom or the necessity of such an enactment. The Act, for whatever reason, has become a symbol of oppression, an object of hate, and an instrument of discrimination and high-handedness. It is highly desirable and advisable to repeal this Act altogether." Unquote. The committee also recommend insertion of appropriate provisions in the Unlawful Activities Prevention Act 1967 to govern the deployment of armed forces of the Union in aid of civil power as and when requested by the state government, but only for 6 months. This will be uniformly applied all over India. In each district of the state where such forces are deployed, the Union government shall constitute a grievance cell, which shall be independent body and shall be competent to inquire into the complaints of violations of rights of citizens. Unfortunately, the government has neither accepted nor rejected the committee's report. Many official commissions and committees have also adversely commented on the Armed Forces Special Powers Act. The 5th report of the 2nd Administrative Reform Commission, focusing on public order, endorses the recommendation of the Reddy Committee, but it proposes that the inserted chapter, the new chapter 6A in the Unlawful Activities Prevention Act, should apply only to Northeast and not in other parts of the country. The Prime Minister's Working Group on Confidence Building Measures in Jammu and Kashmir, headed by the present Vice President Sri Hamid Ansari in 2007, have also recommended the repeal of Armed Forces Special Powers Act. Even the Planning Commission in the 12th 5-year plan document passed by the National Development Council has asked for not only a gender review of Armed Forces Special Powers Act, but also of gendered violence in the disturbed areas, as women and children are the most vulnerable in conflict region. It is also significant that Justice J.S. Verma, who once headed the Constitutional Bench upholding the constitutionality of AFSPA in 1997, in his report submitted to the Government of India in January 2013 following the Delhi rape case, has sung a very different tune on AFSPA this time. The report acknowledges the impunity of systemic or isolated sexual violence in the process of internal security duties is being legitimized by the Armed Forces Special Powers Act, and recommends that so far as sexual offences are concerned, the need to obtain sanction from the central government for prosecution, suit or other legal proceeding shall be dropped. Unfortunately, again, the government completely ignored this part of the recommendation when the actual criminal law amendment bill was drafted and passed. If a person of Justice Verma's standing can reconsider his opinion on Armed Forces Special Powers Act and eventually empathize with the plight of the women living in the disturbed area, there is every reason to hope that the present protagonist of Armed Forces Special Powers Act in position of power will also eventually give in to the call for the respect of basic human rights for all and repeal Armed Forces Special Powers Act. The call led by Irom Sharmila on her 14th year of hunger strike demanding the repeal of Armed Forces Special Powers Act. Thank you very much.